Hello everyone, welcome to Legacy IAS Academy. In this video, we will study about death penalty. This is also called as capital punishment. It is also called as capital punishment. Why is this particular capital punishment in news? And what is the opinion of Supreme Court and the High Court regarding the death penalty? And what has the Law Commission has to tell about death penalty? That's what we'll be studying in this particular video. Let's begin. What is the context? Reforming the death penalty, which means this particular practice of capital punishment, which is also called a death penalty, needs reformation. Why does it need reformation? And what is this particular reform that the author is talking about? We'll see that in a bit. The death penalty, never justifiable, never acceptable. This is against the practice of death penalty. Okay, what is death penalty? Let's try to understand this particular question first. What do you mean by death penalty? Okay, as the name itself suggests, it is the death which is the solution or which is caused as a punishment. It is caused as a punishment. It is a state sanctioned practice of killing a person as a punishment for a crime. Okay, you must be aware of this. You know what death penalty means. Look at here. These are various types of capital punishment. Various types of death penalty for that matter. One is through hanging. We practice this. In India, this is what is being practiced. Shooting, we don't practice this. Lethal injection, we have something called as passive euthanasia. In case-to-case basis, we do not have active euthanasia. In the case, we have something called as passive euthanasia. Electrocution, gas inhalation. Okay, these are the various types which are used in order to kill a particular person so that he would be punished. Okay, he would be punished. Okay, I hope you have understood this. What is the issue now? Okay, we have seen what death penalty is and what are its forms. Why is it in news? So what happened? Okay, the court is undertaking an exercise to reform the procedures. Reform the procedures in which the information is necessary in the death penalty case is brought before the courts, which means in order to decide, in order to give the judgment that capital punishment has to happen with respect to a particular person, the court requires some information. Okay, court requires some information and evidence in order to come to the conclusion. So this evidence, this procedure of finalizing the evidence and submitting it to the court has to reform. Why it has to reform? Because in Supreme Court, it acknowledged the concerns in the manner in which the death penalty sentencing is being carried out, which means the legitimate information, the legitimation or the authenticity of this particular information is under question. So this is what is being asked to reform. It is not the entire death penalty as a practice is under question. It is the procedure of collecting data is under question. How are the judge supposed to choose between life and death sentences? As of now, what are judges doing? In the year 1980, there was a famous Supreme Court case called as Bachchan Singh case. Remember the name, very important. In Bachchan Singh case, the Supreme Court took an opinion that the death penalty is constitutionally valid. Okay, it is constitutionally valid. This was the stand taken by Bachchan Singh case in the year 1980. Okay, in this case, for the future reference, what Supreme Court did was it carried out or it had a framework in which judges have to deliver judgment that death penalty must be carried out. There has to be a framework. There has to be a framework which has to be followed. But was it followed? In reality, no, it has not been followed even now. That is the issue. CRPC had made it clear. CRPC made it clear the life imprisonment life imprisonment is mandatory, and only in the exceptional cases the individual or the accused has to be sentenced to death. Okay, this was the opinion of CRPC. Okay, but the courts took crime-centered approach to sentencing. So what is this crime-centered approach to sentencing? Imposition of death penalty has been arbitrary. This was the concern before. This is the concern as of now also. The death penalty is being arbitrary, and this is the reason why, in order to solve this problem of death penalty being arbitrary, the Supreme Court said the procedure of collecting the information has to be streamlined and has to be reformed. Okay. The project 39A, this is an article number of DPSP 39A. 15 years of death penalty sentencing in trial courts has shown that the Bachchan Singh framework has broken down. We have seen the framework that was set in the case of Bachchan Singh. Okay, and the study which was conducted as Project 39A, as a part of Project 39A, said that the framework that was developed during the Bachchan Singh case was not followed at all. And the issue is of the data deficit. We do not have the particular specific data that can be used in order to provide death penalty. Who can collect this particular information? We are talking about the data deficit. And then how do we make this situation a data surplus? How do we collect data? The Supreme Court has recognized the lawyers. Okay, it has recognized the lawyers in order to collect the information. It is important to collect this complex interplay of information which would be collected by lawyers. This is what is said by the Supreme Court. What is Law Commission's role when it comes to death penalty? Look at here. The Law Commission in 2015, this was headed by Justice A.P. Shaw. He was the chairman of Law Commission, and he said that the abolition of capital punishment is very essential in order to reform the criminal justice part of India. Okay, the Law Commission proposed to abolish or end death penalty. Okay, but here is a catch. According to the commission, India is few countries that still carry out the executions, but this recommendation of abolishing the death penalty is only to non-terrorism cases, which means during the time of terrorism cases, when the court is trialing the terrorist case, then it is bound to provide death penalty. But in case of non-terrorism activities, any crime for that matter, it is not mandatory for the court to trial it with the perspective of giving a death penalty. In other countries, what are the other countries? What are the global examples we have? Look at here. Iran, Iraq, Saudi Arabia, China. In these places, the practice of executions are there. Similar to the death penalty that we have here, the death sentence that we have here, these countries have something called as executions, marks executions that they follow. 98 countries by the end of 2014, now we are in 2022, at the end of 2014, 98 countries had abolished death penalty. Okay, state of death penalty in India. How many death penalty cases we have heard, and how many of them have got the judgment? See here, India has carried out 8 executions since 2000. We are 22 years ahead of 2000, and still we have carried out 8 executions. In that case, how many are accused? How many are accused? How many are convicted? 404 prisoners are on the death row in India, with Uttar Pradesh leading the list, which means there are 404 convicted and trialed people in the prison, okay, who have got the sentence of death penalty. But because of the delay, these individuals have not been awarded with death penalty. It's not being executed. Okay, they are every day they are living in the fear of death. Okay, whenever the death might happen, whenever the court can come up and say that today is your last day. This uncertainty is which these people are living. Okay, this is the state of death penalty in India. I hope you have liked the video. For more such enriching content, please subscribe to Legacy IAS Academy. Have a nice day. Thank you.